Due process is not just some vague hope for fairness. It's actually a public, legally constrained sequence where power is exercised only through known rules, visible procedures, and reviewable decisions. The Fifth Amendment, for example, bars deprivation of life, liberty, or property without due process of law. The Sixth Amendment lays out specific criminal trial protections like notice, confrontation, counsel, and an impartial jury. And Article 3 places the judicial power in courts that decide actual cases and controversies. Those protections are public-facing and structurally accountable. They don't rely on simply trusting administrators. Instead, they depend on a constitutional architecture that limits who may decide, on what basis, through what procedure, and under what scrutiny. However, over the last decade and a half, these protections have been systematically stripped, beginning in college and continuing throughout professional careers. The method has been not legal, but administrative. The creation of alternative forms to resolve disputes. Today we will explore what due process was meant to entail and how universities have led the effort to undermine justice in America. The first due process triad is notice, defense, and accountable adjudication. Its purpose is to prevent the state from surprising a person with an accusation and then punishing him before he's had a fair chance to answer it. The mechanism involves formal notice of the charge, time to prepare, and an opportunity to respond through counsel and evidence. Its application is constrained by constitutional text. The Sixth Amendment requires that an accused be informed of the nature and cause of the accusation, and the due process clauses require lawful procedure before deprivation. In court, this means the person knows the rule alleged to have been violated, the conduct at issue, the evidence relied upon, and the decision-maker who will apply the law. It's public accountability through specificity. The government must say what it's doing and why in a form others can examine. But in systems created for private adjudication, these principles are undermined. The negated replacement triad in alternative adjudicative systems is accusation, ambiguity, and administrative ratification. Here, the purpose shifts from protecting the accused against arbitrary power to protecting the institution against liability or controversy. The mechanism is often a broad internal policy, an investigator-controlled notice process, and a hearing structure that exists only if the institution chooses to provide one or if regulations require it. The application becomes pretty opaque because the operative standards are not really constitutional criminal procedure, but instead things like institutional policy manuals, accreditation pressures, HR codes, professional ethics rules, or even Title IX grievance procedures. In the Title IX setting, the 2011 Dear Colleague letter instructed schools to use prompt and equitable grievance procedures and stated that the Office for Civil Rights expected the preponderance standard. It didn't create Article 3 courts, juries, or constitutional criminal process, but it did pressure schools to build these sort of quasi-judicial systems inside themselves. That guidance was later withdrawn in 2017, and the department's 2020 rule expressly added more formal procedural protections, including live hearings and advisor-conducted cross-examination for post-secondary institutions. However, compliance remains elusive, with many institutions regularly denying representatives to advocate in the hearing setting. A vast web of immunities and procedural difficulties, the challenge of confronting a deep-pocketed school, and the students' implicit need to remain in the institution's good graces combine to shield them from meaningful accountability. And so, universities' procedural discretion only continues to grow. The second due process triad is impartial tribunal, separated roles, and legitimacy through public office. Its purpose is to make sure that the person deciding the case isn't the accuser, isn't the investigator, and isn't a partisan for one side. Its mechanism is role separation. Prosecutors prosecute, defense counsel defend, judges judge, and juries decide facts where constitutionally required. Its application is constrained by Article 3 courts' judicial oaths and public legal standards. A constitutional tribunal isn't just expected to be fair, it's actually constituted to reduce bias structurally. Even where judges have discretion, they operate in a visible office with rules of recusal, appellate review, and record-based scrutiny. That's why impartiality in court isn't just a slogan, but a constitutional arrangement. The negated counterpart here is what we call institutional fusion, mission bias, and self-validation. In lots of alternative systems, the same organization is the one writing the rules, training the adjudicators, appointing the investigators, defining what's relevant, and it also bears the reputational risk of whatever outcome is reached. Universities, licensing boards, and professional associations often present this as expertise, but structurally, it's really just concentration. The person or office gathering the facts might also be shaping the charges. The adjudicator could be embedded in the same bureaucracy. The appeal might stay internal, and then the institution declares the resulting process equitable by referencing its own standards. The structural danger is, I think, pretty obvious. Once all these roles collapse into a single administrative pipeline, impartiality no longer comes from constitutional design. Instead, it just depends on internal goodwill. The 2020 Title IX rules insistence on objective evaluation of inculpatory and exculpatory evidence in live hearings at post-secondary institutions is, in effect, an admission that school-run systems often lack enough separation and adversarial testing to inspire real confidence. The third due process triad is evidence, confrontation, and disciplined fact-finding. Its purpose is to test truth claims, not to reward whichever side is institutionally favored. The mechanism is adversarial examination. Witnesses testify, evidence is disclosed, adverse assertions are challenged, and credibility is tested in real time. Its application is constitutionally constrained, most explicitly in criminal cases by the Sixth Amendment's Confrontation Clause and the guarantee of assistance of counsel, but more broadly, by due process itself, which rejects secret or one-sided deprivation. The point isn't theatrical combat. It's about epistemic discipline. Facts only become legally trustworthy after they've been exposed to challenge. The negated replacement triad here is allegation, paper review, and administrative credibility assignment. In alternative adjudicative systems, especially those designed for speed or what's called trauma-informed institutional response, the mechanism often shifts away from confrontation and toward file-based investigation, interview summaries, restricted questioning, or screening by administrators rather than live adversarial testing. That doesn't just soften the process, it actually changes the logic of proof. The system stops asking whether a claim survives challenge and instead asks whether an administrator finds the narrative sufficient under internal policy. The department's 2020 Title IX overview emphasized that for post-secondary institutions, schools must hold a live hearing and allow cross-examination by party advisors, and that all relevant inculpatory and exculpatory evidence must be objectively evaluated. Those requirements were added by regulation. They weren't features of the 2011 Dear Colleague regime itself. That historical sequence matters because it shows that the alternative campus systems formed after 2011 weren't structurally equivalent to courts. They were substitutes with much thinner mechanisms of truth testing. The fourth due process triad is law, record, and reasoned decision. Its purpose is to ensure that power is exercised according to a known rule rather than administrative instinct. Its mechanism is a defined legal standard, a record of what evidence was considered, and a written decision explaining how the rule was applied to the facts. Its application is publicly accountable because appellate courts, litigants, and the public can inspect the reasoning. Even when a court errs, it errs on the record. The decision can be criticized, reversed, limited, or distinguished. This is one of the deepest constitutional protections, not simply that a person gets a hearing, but that the hearing culminates in a reason-giving act constrained by law. The negated counterpart is policy elasticity, closed record, and discretionary conclusion. In bar disciplinary matters, campus systems, and other extra-court forums, The nominal rule is often a highly elastic code of conduct or professional standard rather than a legislatively enacted, judicially bounded legal rule. The record may be partially confidential, inaccessible to the public, or curated by the institution itself. The final decision may explain little beyond the administrator's conclusion that the policy was or was not violated. Once that happens, the form of adjudication remains, but the constitutional substance has been replaced. The affected person faces not law in the public sense, but managed compliance review inside an organization that claims authority to define both the rule and the method of deciding it. That is not due process secured by public accountability. It is process secured by internal authorization. The fifth due process triad is publicity, review, and external correction. Its purpose is to prevent closed systems from becoming self-justifying. Its mechanism is public proceedings where constitutionally required, appeal to a superior court, and standards of review that permit legal error to be identified and corrected. Its application is what turns a legal process into a public one. Even when not every filing is front-page news, the system exists in principle before the public, under published rules, with published precedents and review by institutions not controlled by the original decision-maker. That externality is crucial. It means the system cannot be judge, jury, and historian of itself. The negated replacement triad is confidentiality, internal appeal, and institutional closure. Alternative adjudicative systems routinely justify secrecy as privacy sensitivity or professionalism. Sometimes that justification is legitimate in part, but structurally the cost is immense. If proceedings are hidden, if appeal stays within the same institution or professional guild, and if the standards are framed as specialized internal expertise, public accountability disappears. The system may be legal in the sense that statutes or regulations permit it, but it is no longer constitutional in character. It cannot correct itself through the same public law mechanisms that discipline courts. The result is a sealed loop. The institution accuses, investigates, adjudicates appeals, and then points to its own completion of the process as proof of fairness. The Title IX example is especially instructive because it shows how quickly an administrative workaround can be normalized. The 2011 Dear Colleague letter pressed schools to adopt prompt and equitable grievance procedures and identified preponderance as the standard OCR expected in evaluating complaints. It was guidance, not a constitutional amendment, not a statute enacted through bicameralism and presentment, and not a judicial opinion after adversarial litigation. Yet it had sweeping practical effects, because institutions rearranged their internal disciplinary systems to satisfy federal enforcement expectations, and once they had assumed that power, they would never let it go. The department withdrew that guidance in 2017 without effect. The 2020 Title IX rule replaced it with more explicit procedural protections, though only in the context of Title IX sexual harassment cases, including live hearings for post-secondary schools, advisor cross-examination, objective evaluation of evidence, written determinations, and rape shield protections. However, schools got around this by simply classifying a large share of cases into the non-Title IX track and keeping the thinner administrator-controlled process there. And even the guidance that remained was further eviscerated over the next few years. A federal court vacated the language that had barred decision-makers from relying on statements of a party or witness who did not submit to cross-examination. OCR says it will no longer enforce this portion. A new rule was introduced in 2024, but immediately repealed on Trump's ascension to office, allowing universities to continue as before, as judge, jury, and executioner. Even attempts at reform only serve to demonstrate exactly why alternative adjudicative systems are so flawed: lack of accountability, the absence of a way to mount a meaningful challenge, and the ultimately discretionary nature of any attempts to correct them. So the deepest comparison is this. Constitutional due process operates through affirmed public triads. The purpose is protection against arbitrary deprivation. The mechanism is a constrained judicial process, and the application is answerable to public law. Alternative adjudicative systems operate through negated administrative triads. The purpose shifts toward institutional management, the mechanism becomes internally designed procedure, and the application is answerable chiefly to the organization administering it. One system assumes power must justify itself before the public. The other assumes process is fair if the institution says it is. That is why these systems are not merely different versions of the same thing, they are structurally opposite. Courts derive legitimacy from being outside the disputing institution and inside a constitutional order. Alternative adjudicators derive legitimacy from authorization by the very bureaucratic or professional structures whose interests are implicated. However polished they may become, that substitution does not cure the defect. It is the defect.